Former President Donald Trump has been held in contempt of court by New York Judge Arthur Engoron for failing to comply with the terms of a subpoena issued by the New York State Attorney General Letitia James in connection with a probe of his business practices in New York State. Trump will be fined $10,000 per day until he complies. What does this mean for the Donald or anyone else who has ever served with a subpoena? A subpoena is a very powerful document used in connection with litigation throughout the country and throughout the world. A subpoena can be served on someone to provide testimony or to produce documents, or both. Anyone who is served with a subpoena and feels it is not justified or proper can make a motion to quash it. That's a legal term for get rid of it so I don't have to comply. And that's what exactly Donald Trump did in this case when he was served with a subpoena to produce certain documents. But he lost. He lost the motion to quash the subpoena and was directed to comply with its terms. The subpoena was originally returnable on March 3rd, which means Trump had to provide the documents requested in the subpoena by March 3rd. His attorney requested an extension, which was granted to March 31st. Because Trump failed to comply by the scheduled date, Justice Engoron held him in contempt and found that his repeated failures to comply with the terms of the subpoena and respond to it left him no choice but to hold him in contempt and to fine him $10,000 a day until he does. Andrew Amir, Special Litigation Counsel to the Attorney General's office, stated that the fine is not meant as a punishment to Trump, but as an incentive to get him to comply. Trump's attorney, Alina Habba, stated that Trump just doesn't have the documents. He doesn't have emails, he doesn't have text messages, and he actually had to travel down to Florida to meet with Trump to go over what was being requested. And he says Trump doesn't have them. Whether or not you believe that is a whole other video and a whole other story. But for the purposes of this video and Justice Engoron's contempt order, all you need to know is if Trump did not have the documents, all he had to do is provide an affidavit. The affidavit needs to state what efforts were made to search for the documents, that these documents do not exist, or if they did exist, they no longer existed, and this is a process of what happens. But he needed to provide some affidavit explaining his response and not just ignore it. Habba also stated that they disagree with the court's decision and they will appeal it. So what happens to the $10,000 a day fines while Trump and his attorneys are appealing the contempt order? Well, they need to request a stay or a restraining order to prevent the time and the money from accumulating while the appeal is pending. The appeal could take years for it to be decided. And $10,000 a day over a year or 2 years or whatever time it is going to add up. And no matter how rich you are or how much money Donald Trump has, it's better not to pay $10,000 a day than to pay $10,000 a day while you're waiting for the appeal to be decided. So they need to request an injunction or a stay of this order while the appeal is being decided. If the order stands and Trump continues to ignore the request and fails to comply, the fine could either be increased or the judge could throw him in jail for being in contempt of court and not complying with the subpoena term. The underlying basis of Letitia James's investigation into the Trump Organization is whether or not the former president's New York City-based company misstated the values of its real estate properties to obtain favorable loans and tax deductions. The Attorney General claims that the 3-year probe has found significant evidence that the company included misstatements of asset valuations in its financial statements for over a decade. The Attorney General has questioned the value of the Trump brand, as well as other properties, including clubs in New York and Scotland, golf clubs in New York and Scotland, and Trump's own penthouse apartment in Midtown Manhattan, known as Trump Tower. At the same time, Justice Engoron granted a motion by Letitia James's office to compel a real estate firm known as Cushman & Wakefield to comply with certain subpoenas to conduct appraisals for several Trump Organization properties. Trump and 2 of his children, Ivanka Trump and Donald Trump Jr., were also subpoenaed by the Attorney General's office to provide testimony. That is under appeal, and they still have failed to appear to give any testimony with respect to this investigation. The Trump Organization's property valuations are also the subject of a criminal probe by the Manhattan District Attorney's Office, which last year led to the indictment of the company's chief financial officer. Trump, of course, is denying any wrongdoing and is claiming the investigation is a political witch hunt because Letitia James, the Attorney General of New York, is a Democrat, and Trump, as you know, is a Republican. Trump is appealing the contempt order, and he's also appealing the order on the subpoenas compelling him and Donald Jr. and Ivanka to appear and give testimony with respect to this investigation. The Rizzuto law firm is a litigation firm. We represent people who have been neglected in nursing homes, who have been the victims of funeral home neglect, who have been victims of car accidents, slip and falls, construction accidents, cosmetic injuries such as waxings and laser treatments. And we utilize subpoenas in almost every case, especially when it comes time to prepare the cases for trial. Preparing a case for trial, one of the first things we do is subpoena the adverse party to appear as a witness on our case. We will also subpoena non-party witnesses so that we have jurisdiction over them and can get them to appear on our case. And if anyone fails to appear, we will request that the court hold them in contempt. We also utilize subpoenas to get certain documents into court so they would be admitted into evidence. We are unable to just take the records from our file and offer them into evidence. We have to serve a subpoena on the institution we want the records from, request certified copies of the records or originals, and those records then can be entered into evidence provided the proper foundation is laid to get them into evidence. And again, that can be the subject of a whole other video. During the course of a litigation, sometimes we will use a subpoena to get certain documents again, to get a witness to appear and give testimony for two reasons. One, we want to know what the witness says. Usually we'll have a statement from that person beforehand so we know what they say before we subpoena them to provide testimony. But one of the reasons that we do it, in addition to getting the information, is so we preserve that information for trial, so that if we subpoena them for trial and they do not appear and we could establish a foundation, we can read the deposition testimony into evidence at the trial of the matter. If you were the plaintiff, the person who is bringing the lawsuit, or the attorney representing the plaintiff, the person who is bringing the lawsuit, the burden of proof is on you to prove your case. So you need to dot your I's and cross your T's and cover all the bases in order to make sure that you have the evidence that's going to go before the court and the jury that will be able to lead them to make a decision in your favor. And in order to do that, you need to utilize subpoenas and the subpoena power that is granted so that you could compel people. You could compel people to appear and comply and provide information that you need in order to be successful in your litigation. Donald Trump has the money to fight this. I anticipate that he will fight it as much as he can. But the simple truth of the matter is if what his attorney is saying is true, and he simply does not have the information, all he needs to do is provide the affidavit stating he doesn't have the information, what efforts were made to obtain the information, what can be done to get the information, and it's over. It is over. So I'm not exactly sure why that wasn't done. I imagine his attorney is, one, very well paid, and two, knows a thing or two about what he was doing. So why wouldn't you avoid this? Why wouldn't you avoid the bad publicity and just provide an affidavit and say, we don't have it? My guess is because the affidavit may lead to more subpoenas and more information requests, but who knows? It's only a guess. If you found this information useful, or if you have questions, if you or anyone you know is ever served with a subpoena and you have questions, always feel free to give me a call. We are happy to answer questions. We don't charge for questions or consultations. The number is 1-855-RIZZUTO, RIZZUTO. The office is located in Long Island. We handle cases from New York City, all over Long Island, to Montauk, up in Westchester, up in Orange County even, we have some cases. and really wherever it is that we need to go. If I can't help you, I can find somebody that does. So I encourage you to give us a call. Don't hesitate to reach out, even with questions or just to say hello. If you found any of this information useful, check out the other videos on my channel, subscribe to the channel, and I will see you there.